Welcome back to You and Your Taxes. My guest once again is Neil Shah, wills and estates attorney. We're talking about the estate planning process. All right. So Neil, you've covered substantially a number of things of how to get started with the whole process. We've even talked about divorce. Now, there's such a thing as you call a funding meeting. Right. Now, this is where you, I assume, talk about all the funds. And when you say a funding meeting, is that just with the specialist, the advisor, or does this involve the family at this stage?
I think it predominantly has to do with the family. Okay. But when I say the family, I just mean the family that we're planning for, the mom and dad, not necessarily the extended family yet. That's going to happen at the next step. But during the funding meeting, or also we call it the asset integration meeting, to step back, fundamentally there's three ways that things pass down. If I were to pass away, the three ways that things are going to pass down are going to be either by beneficiary designation. So items like 401ks, life insurance, annuities, IRAs, all that sort of stuff, they don't really care what's in my will in most cases. They don't care what my intent was. They're going to look at the actual beneficiary designation, and the beneficiary who I named is going to be the person who actually receives it. The second way that things pass down is by title. My wife and I own a house together. If I pass away, my wife continues to be the joint title owner. She'll become the owner. Same thing with bank accounts that are joint titled. The third way is going to be the will. So why is that important? Well, I have different assets and they're all going to be titled differently. They're all going to have different beneficiary designations. So just preparing your will, just preparing your trust is probably not going to be enough. You need to take a look at all of the assets and you need to understand how it integrates along with the will, how it integrates along with the trust. So you might have to point certain things to your will by naming a trust in your will as a beneficiary. So you have to look to see how titles are held, how beneficiary designations are held, and then how everything else is titled so you know whether or not things need to be shifted around to make your overall goals accomplished.
In the event of a death, in the event of something unexpected happening, this is a question that just came to my mind.
Sure.
Can a clause in the will, can a clause in the estate plan, in whatever document is prepared by the preparer, can that be disputed in a court of law?
Yes. In fact, the whole system behind probate, which is what happens when somebody passes away, is intended to preserve people's right to dispute. So what happens when somebody passes away? When Neil passes away, somebody's going to go to the county clerk where I live, give my will, give my list of assets, and actually say, Neil's no longer here. Here's the stuff that you have. Under the probate process, all of my next of kin need to be notified. And the whole idea is if I squeeze somebody out or somebody's getting squeezed out, they should be notified. So that opens up the opportunity for somebody to contest. And this is common in a divorce situation where somebody was supposed to have been named. So sometimes people preserve privacy by using a living trust. So they'll actually create a receptacle where they'll actually put their assets in now so that you don't have to deal with that probate process and it reduces the chance of a dispute.
Okay. And finally, Neil, there's got to be communication, obviously, within the family.
Correct.
I mean, if I draw up a will, I create my own estate planning and all the rest of it, somebody's got to be told, all right, this is what's going to happen. We've heard about the death of Prince, for instance, and we've heard about Michael Jackson. There have been disputes. So these are cases that bring to my mind the fact that somebody has to be told what's going on, because if not, am I right in saying that you're opening yourself up after you pass to all kinds of things going wrong and things going on forever?
Yeah, certainly. I mean, look, people engage in this process because, like I said, there's somebody who they care about. And you've asked, when is it time to get the family involved? That is the time to get the family involved. Get the wills, get the trusts signed, get the assets integrated, but then have communication. And I don't mean just among the family. If you've named somebody as a trustee, a backup trustee, a guardian, a backup guardian, an executor, have a conversation. A lot of people are nervous because they don't want to share their asset information. Don't share your asset information. All you do is basically have a conversation, get the attorney, get the advisor involved in that conversation, and at a high level explain, look, this is what my plan is. This is what your role may be if something were to happen. You don't have to do anything right now, but if you're ever called upon, I just want to make sure that you're comfortable with this. And if you have that communication, two things happen. First, you feel more confident that your plan is going to succeed. And secondly, you've basically opened up this communication tool so that if something did happen to you, these guys know that you've already engaged in this planning, so they know to look for the documents.
And final piece of advice I'd like to ask you, just for informational purposes, but if someone has assets around the world, how soon should they get down to this business of actually preparing a will and planning the estate?
It's crucial. Right away is an answer. Of a very common theme that I'm seeing right now is my NRI clients who are in their 50s to their 70s right now still have substantial assets in India. And if they have substantial assets in India and they've raised their kids here, their kids have very little likelihood of actually settling back in India. So their question is, well, I have all this wealth in India, how do I make sure that my kids get it? And it's a conundrum here, because especially if a lot of it's in real estate, the question is going to be, well, if they sell it in India, they're going to get a black price and a white price, and I can only get the white price over here, so how do I... It's a dilemma. So my suggestion to everybody, as unscientific as it may be, is when the time's right, liquidate it, bring it over here. Because otherwise, but in short, to answer your question, the planning has to happen right away, regardless of whether or not you can liquidate it. Have a basic will or something in India that addresses the Indian assets immediately.
Okay, thank you, Neil. Thank you. You've, as usual, been fascinating and answered a lot of questions from me and educated us about a lot of things. Thank you very much for joining us. Once again, viewers, my guest has been Neil Shah, Wills and Estates attorney. We were talking about the estate planning process, and this has been a special edition of You and Your Taxes. We'll see you on the next episode. Thank you for joining us. I'm Rohit Vyas.